Hello, and welcome back to Immigration News and Views. This segment is called What You Need to Know About H-1B Audits and Investigations. And my name is David Nachman. I am one of the managing attorneys at the NPZ, Nachman Fawani Zimochek Law Group, with offices in Ridgewood, New Jersey, also offices in Midtown Manhattan, and we have an affiliated office in Mumbai, India, and also in Canada. So, as mentioned, today we're going to talk a little bit about H-1B audits and investigations. And I guess to begin, one of the things that's really important for you as business people to realize is that an investigation or an audit can happen at any time. And the most important thing for you to do is to make sure that you have a point guard or a person who is receiving individuals at your place of business or receiving the telephone calls. Oftentimes that's a receptionist or the person at your main desk, and you need to train them a little bit about what to expect in the event that someone from a government agency shows up on the doorstep and has questions or is serving some type of document or is requesting an investigation. So the way that you do that, I think, is to sit down with your receptionist to explain to her that there are several different types of investigations that could potentially incur, at least from the immigration side. So one of the investigations that can happen is what's called an I-9 audit. We talked about I-9 audits in some of our previous videos. However, we're going to be doing some more videos for you that explain how to deal with officers when they show up at your door and how to organize yourself in such a way that you can get them the documentation that they're requesting in a timely manner, because failure to do so can result, of course, in additional penalties to your organization. The second type of audit which can happen is where the U.S. Department of Labor has a wage and hour division officer who would show up. Oftentimes, these individuals come to the place of business as a result of a complaint by either a former employee or a current employee. And usually it's a result of an employer who is not doing something that they're supposed to do under the H-1B regulations. Now, as many of you know, because if you're doing H-1Bs, you're required to have what's called a public access file. The public access file is required to be on the premises at the place of business within 24 hours after the LCA, the labor condition application, is filed with the U.S. Department of Labor. That public access file has about 5 or 6 things in it that are required by U.S. Department of Labor regulations to be contained in the public access file. For example, 1 is a copy of the LCA. 2 is, of course, a copy of the objective wage methodology. 3 is a subjective wage methodology. 4 is proof that there was a posting of the LCA. Another thing that you have to have in there is proof that the individual for whom you are doing the LCA or the H-1B is being paid the same benefits as U.S. workers, and that they're not displacing U.S. workers. So for more information about what needs to be contained in that public access file, please feel free to reach out for us, and we're more than happy to provide you, as a courtesy, with a list of those documents which need to be in that public access file. So if the Department of Labor shows up on your doorstep, what do? Well, your receptionist or the person who's greeting people should take down the appropriate information and should immediately contact a member of the Human Resources Department, someone who is adept at knowing where the public access files are, where the I-9 forms are, and where this information can properly be gathered for the investigator. Oftentimes what they'll do is they'll come with a couple of pieces of paper, they'll give it to the Human Resources Manager, and they'll ask them to sign for it, and then that information obviously should be either you can do this in-house, or you can reach out for your appropriate legal counsel who might be able to assist you in putting together what you would need in order to provide the U.S. Department of Labor with the documentation that they're asking for. Now, oftentimes, again, sometimes these cases come up as complaints by employees who allege that they haven't been paid the federally mandated prevailing wage. And so that would be probably within the bailiwick either of the corporation or within the bailiwick of their outside counsel to make a determination as to whether or not the allegations are or not true, and then of course to present information and documentation such as payroll records or other tax records to show that the individual was or was not paid the appropriate federally mandated prevailing wage. So we're going to talk more about this in another video, but we just wanted to give you a basic idea of what you as an employer can possibly expect in the event that a government investigation is instituted against your organization. Thanks very much for tuning in, and we look forward to seeing you soon. Bye for now.